Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Cison. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Cison.
Hi, everybody, and welcome to the April 2025 Third Fridays podcast edition or episode. My name is Christian Cison. We've got a great and jam-packed show for you today. Before I get into it, we can recap really everything that's been happening over the last quarter. It's been a very quick Q1 for Lois Law Firm, and we have talked about so much internally that obviously is not fit for external consumption, but we have talked a lot about our ideal, culture of this great practice, great life. And I think if everybody were to review the last quarter's episodes, I think particularly even the paralegal journey starring Ryan Wallace and Derek Romberg, you can really talk about how Lois Law Firm really contributes to its employees' lives and creating a great balance between what we do here at the firm in these four walls and what we do outside. So take a listen over the last quarter. We got some great content for you. Today, a little bit different. We're going to welcome back, a very, very often invited guest to the show. We also, in our second part of the episode, will preview this year's mock trial season. So we're going to get to our committee in part two. That's Karen Olarte, Moshe Allweiss, and Anthony Iler. But right now, I want all our listeners to really listen up and say happy birthday to our good friend and partner, Addison O'Donnell. Welcome back to the show, Addison.
Thank you very much, and thank you for the birthday wishes. I prefer carrot cake for birthday cake.
Okay, you hear that, guys? So when you hear this, we won't be his actual birthday, right? But if you want to send carrot cake to Lois Law Firm, that is, if on Wednesdays and sometimes a third Friday here and there, that's 66 Route 17 North in Paramus. Tuesdays and Thursdays, may want to send it to 140 Broadway, Manhattan, just so that the great Addison O'Donnell can celebrate his birthday with your gift. But Addison, if you're coming on the show today, we're probably talking about something with appeals, right?
I mean, that would be a very good guess, but yes, absolutely.
And so when we talked about this particular episode, you making another guest appearance, and I have to check the numbers, go with producer Grayson on this, but you might have the most episodes guested. No,
that's got to be. I mean, that's got to be like Declan or Joe, Tashia, folks who've been here since day one, who've defended since day one.
Oh, look at that. Okay. So actually, did anybody have that in their bingo card? Someone else saying defend from day one before me on any show ever. Okay, so we have this appellate division opinion from the third department. It's Sutphin versus UPS. And I think if most practitioners were to look at it, do they bat an eye over it? I'm not sure that they think, this is going to change the game. This is going to change my process, my way of representing claimants or carriers, employers. But I think it's especially interesting to legal nerds like you and me. So, there might be a few other people out there. Why does this case speak volumes to you before we get into the nuts and bolts?
Well, the first thing about this case that everyone should know is that it's one of the most interesting apportionment workers' compensation decisions in the past couple of years, because it's not really about apportionment at all. So there's this concept in workers' compensation called apportionment. If if an injured worker has had a prior injury or ailment to a similar site or same site over the past, several years, one can obtain, a carrier can obtain an apportionment defense where It's essentially it's a no causal relationship or partial causal relationship finding, where this specific site or this specific injury is not because of the date of loss, it's because of something that happened before the date of loss, and we must apportion it accordingly. That being said, the first page of the decision is describing the relative claims, right? There's a first claim from a 1995 accident. There's a second claim from a 2001 accident, and then there's a third claim from a 2017 accident. So we have, we have essentially 2 decades of injuries, ailments, degeneration, and we're trying to figure out what belongs to what injuries are because of what claims.
And you see this happening, right? Maybe just for particular background, right? At a prior firm, I actually represented UPS for a period of time. And they had many claims like this where you had an accident, a work accident, and they came back to work and they had another work accident and they had another work accident. I think what's very interesting about this one is the timeline between all 3 accidents. It's, this claimant had the second work accident in 2001 and works straight, presumably without any work accidents for 16 years, and then has this 2017 work accident that is now the subject of apportionment. And I think before, you coined it actually pretty beautifully that I didn't even think of that topic at all when you're saying it's about apportionment, but not, right? Off the jump, you have this 2017 accident, and I'm thinking to myself, what are the chances that a 2017 accident can actually be materially apportioned back to accidents 16 years ago? I think because that to me was interesting in terms of the investment of litigation expenses into apportionment when perhaps the likelihood is not that high.
Yeah, this is a very thorny and layered issue in the apportionment world. Apportionment can be split essentially into 2 concepts. One is called medical apportionment, in which a medical professional, specifically an independent medical examiner, an IME, opines that the disability is not causally related to this specific work injury, but related to prior injuries. That medical apportionment is litigated in the same way as causal relationship, degree of disability, treatment plans, where, my doctor says X, your doctor says Y. It's a battle of the experts. So medical apportionment really boils down to that. There's another area of apportionment, and we can have an entire episode about that in and of itself, that we like to call legal apportionment. And legal apportionment is essentially statutory, right? When we have occupational diseases, for example, under workers' compensation law, section 44, occupational diseases, particularly those that are as a result of repetitive use during work, can be apportioned to prior employers. The last employer on the risk of the date of disablement can essentially carve out percentages based on a claimant's length of time in prior employments. We see that with union records that are submitted, and we get 20 carriers, placed on notice, all fighting. That's one example of, legal apportionment. In this particular case, it deals with the special fund, which is another statutory, 25A way to apportion. It's really becoming, out of vogue, if you will, because it's extremely fact specific, and it's neither here nor there for the purposes of this episode. But just thinking about it, is it evidentiary apportionment? Then that's probably medical, right? My evidence versus yours. Is it legal apportionment? That means there's a statute that entitles me to carve out percentages.
That's a great explanation. I think especially because the special funds involvement in cases is getting more rare, right? Due to the application of those statutes, specifically 25A. These 2 prior claims had instances where the special fund accepted responsibility. And then there's clearly no acceptance of responsibility for a much later claim where 25A wouldn't apply to the new claim. So the judge, as you know, if you just listen to Addison's tremendous explanation there, you don't understand then why the judge found no basis for legal apportionment, or at least can understand why the judge would do that, right? So the judge says that you cannot use the statutes or law or any kind of authority to legally apportion liability of your 2017 work accident to the 2001 accident or the 1995 accident. Am I getting that right?
Yes. And the judge found no basis because there's, and again, it's neither here nor there, there's another statute, Section 123, which most listeners would know based on the board's continuing jurisdiction. But it's also, it's really the statute of limitations for filing and continuing to pursue a claim. There's a very complex rule called the 18-year rule with regard to closures, so that these are all questions of fact, and a judge determines questions of fact based on the record that was developed before the court. And the judge said, nope, this 2017 accident is not apportionable to the prior two claims, and Liberty Mutual files an appeal in the third claim, in the most recent claim, which leads and precipitates to this decision.
Right. They file an appeal to the board panel, and the board panel says, we're not going to hear your argument. We're rejecting your appeal, essentially affirming, well, maybe not affirming, but essentially keeping in place the law judge decision, because Liberty Mutual or its counsel or UPS's counsel, they filed the appeal in the 2017 claim and did not file the appeal in the 2001 or 1995 claim.
Correct.
And I'm sorry, go ahead.
So, well, this is the most interesting part of that procedure here, is that when the board denies an appeal, if the board says, no, I'm not entertaining this, we focus on what the court does and not necessarily what the court says. And so if that's why, it's interesting. You said, well, the board panel didn't affirm the underlying decision. It just denied the application. Implicitly, it did affirm the underlying decision, which led UPS to appeal to the Appellate Division, Third Department.
Yeah, it's just in case anybody missed that, it's a very, very big O'Donnellism there. Focus on what the court does and not what the court says. Right. You hear that very often. That's coming from him. And so the board is going to now reference this subject number for all you comp nerds out there. That's 0461106R, where they're saying that if you don't have a separate copy of your appeal pleadings and brief in every single file that's being involved, they're saying they're not going to hear it. They're saying that it would be a duplicate filing and you might get penalized. And, from an administrative perspective, I can understand the reason to do that, right? Because it causes more administrative work on the board's end if they're saying, okay, look at all these other files, and they have to do the work to kind of, I don't want to use the word travel because I think industry professionals probably think of something else, but kind of put them all together on the desk, so to speak, so that you can look at all three files in this case. So I can understand why that rule exists, but not enough in this case.
And I also understand why UPS appealed only in the third case, because the judge made a decision only in the third case. This case is not apportionable to the first two cases. A lack of a decision, in the first two cases, while it can be an appealable decision, there was nothing that was adverse to UPS in those two cases.
And I wonder if they were even a party of interest in the prior two cases.
Good point. We don't know.
There's no guarantee that UPS or Liberty Mutual representatives have electronic access to the board file if they receive decisions from that case. For example, I think to almost require them to file in a second and third case begs the question of, well, can you guarantee that the notice of decision in your case has the same filing date as the ones in the other case? I mean, I would say 100% of the time, I think I've looked at when in those types of situations, they are, because they all get filed on the same day. But if you don't have access to the other claims, how can you be the person that's required to file there? But in any event, it doesn't preclude you from filing something in a case just because you're not a party of interest. So I guess I can see it from both sides. Why did the appellate division have an issue with that ruling?
Well, that's the $1 million question. And it is such a complex question that in order to understand this decision, we have to understand how the law works in New York. And in order to understand how the law works, we have to pretty much take a total view of the legal system itself. So, of course, we have Schoolhouse Rock, right? The executive carries out the laws, the legislature makes the laws, the judiciary interprets the laws. And these three parts of government, branches of government, all carry out our day-to-day life, right? And so the legislature, for all intents and purposes, sits down and legislates. They create laws. And, it's not from whole cloth, right? They might receive a template from lobbyists. They might receive templates from insurance companies, right? Or from unions or whatnot. It becomes a discussion. It goes to committee. The committee votes on the bill. Then the bill goes to the floor, right? In the assembly or whatnot, or in the Senate. Usually it starts in the assembly. The assembly votes on it. The Senate, reconciles it. Sometimes it needs to reconcile back to the assembly. It winds up on the governor's desk. The governor signs it into law, right? This is Schoolhouse Rock. But the reason why I have to explain this is because after a statute is created, then the executive occasionally needs to carry out the laws in a certain way, right? Some legislative acts are not self-executing. It's impossible based on how they were written or based on the function. And that's where we get our majestic workers' compensation system, right? That's an administrative executive function. And so under the tenets of administrative law, right, the executive can carry out the rules that the legislature prescribed, that the legislature wrote, by writing regulations, rules and regulations, which interpret the law. It has the weight of law, maybe not as much weight as the statute itself, but it's rules and regulations. And it's these rules and regulations that we know and love here in the workers' compensation world, here at Allweiss Law Firm, right? We talk about 12 NYCRR 300.13. That is a regulation, right? This regulation interprets, and in and of itself is law, what the legislature gave to the Workers' Compensation Board.
And you have a situation now where the regulation does not talk about what the subject number discusses.
Right.
And I don't even, because subject numbers have been issued by the board forever. I mean, it's not like I don't perceive, just as a matter of course, that the board is enacting subject numbers as an end around of the legislative process. I don't see that happening, but I guess there could be a worry that this is happening. Sometimes subject numbers are really done to provide immediate notice to all stakeholders about something that the board is going to be addressing, almost to prepare its stakeholders for a particular result. And I don't think that, that part of the concept is wrong, but I think when it's used to really deprive a party's due process here, we have, I wouldn't call it a huge problem, but you definitely now need to look at how you're applying subject numbers, right, from the board standpoint.
Right, absolutely. And it's funny because 300.13, the regulation, that's subject to a notice and rulemaking comment period. It's subject to the public's input before any regulation becomes law. And it is a regulation, it is law. Subject numbers are written by the board or the Office of General Counsel for the board. And subject numbers essentially interpret regulations and statutes. It's advisory guidance. It's not law in and of itself. I love the novel To Kill a Mockingbird. It has the same legal weight as me citing To Kill a Mockingbird. Maybe it has a little bit more because it's the board itself, because of the authoritative nature of it. But this is the Office of General Counsel reading the regulation, reading the statute, and explaining pretty much in a recipe format on what to do in the situation. And the third department understands this because that's day in and day out for the judiciary, right? Outside of the executive branch. That's the most interesting part of this case to me, is that I actually might disagree with you, Christian. I think the board did use the subject number
as an end around.
Oh, okay. for the legislative and notice of rulemaking process, because the court here says that the board indeed can promulgate regulations, but it was an abuse of the board's discretion to cite this subject number essentially as an end around to the regulations themselves.
That's a good point. Actually, now that I think about it, the text of the subject number actually tells us that they were intending to use that.
Yes.
Right? Because if you are going to say, here's a subject number, here are the newly authorized providers in New York workers' compensation, or these are the providers who are on suspension or whatever, we'll know not to use them, or how we're going to cross-examine those types of experts. But you're right that the text within the subject number does evidence an intent to use that subject number in opposition to what the regulations say or omit. And so what do you think about the appellate division's comment outside of the regulations? Like when they're saying it's not included on the form or in the instructions to the form, do you think that if the board put these instructions on the form, but the regulation still stayed silent, would we have the same outcome?
This question is actually a question about discretion. And discretion is a fancy legal word for power. The question that you asked me is actually a question about power. Does the board have the power to rule on something wherein the issue is not included on the form or the instructions to the form or in the board's regulations, right? Abuse of discretion means abuse of power. Discretion means the board can choose to do one thing or choose to do the other. It's funny because the judiciary is very sensitive to abuses of discretion. That's legal reversible error. That's one of the highest forms of reversals in our system. And so when we're looking at this and when we're analyzing, it's as simple as you didn't fill out the form right. The fact of the matter is that if the subject number says the board can, in its discretion, throw it out, but that has no legal weight in the same way as a regulation, 300.13, or as a statute, Section 23, that's really what it all boils down to.
That's incredible. I started to read this opinion and almost, just like with most cases, I want to picture myself as a practitioner within the case. So I'm envisioning, e-case with my 3 board case IDs, my apportionment arguments, evidence that I'm going to use for medical apportionment, which, the law judge held in abeyance, in the underlying facts. But as we talk about it, and even live here, not even talking about prep, live discussion with you has made me really look at this case in a different light, where I don't even really care so much about the facts of the case. It's the concepts and what the parties are really going through to execute the concept within these frameworks. It's really fascinating. But Addison here, you're citing Schoolhouse Rock and To Kill a Mockingbird. So if anybody didn't listen to anything that we've said in the past 2 or 3 minutes, we have to forgive them. This is just great references. Who better than to, bring to mind Atticus Finch, one of the greatest lawyers of fictional time, right?
I tend to, when I talk about the law, I tend to try not to be like a vacuum cleaner. I don't want people to just tune me out. But these nuances here in this case really speak to the future. It really speaks to the future of what board subject numbers would mean. So I don't want to, read tarot cards here, but why not? If there is a board subject number that colors outside of the lines of the regulations and colors outside of the lines of the statute, that suggests, and if the board relies on that in making a decision, that subject number which colors outside of the lines, I think a similar result will occur.
It has to.
It has to.
It has to. If you're talking about a situation here where, factually speaking, if the board just reviewed this appeal and said, you know what, the law judge was correct, right? I think it goes nowhere, right? And maybe it still does, but this has so much power because you have to go by the Schoolhouse Rock rules, right? Like you have to proceed in a way that everybody has the proper notice to do things that have some measure of predictability, that people can say, okay, I'm going to do this knowing the result, because that's how laws work. But yeah, really, really great analysis on your end. What do you think that the board is now going to put more investment in creating, amending, modifying regulations, or do you think that subject numbers are going to be more, I don't know what the phrase I'm going to use or the word, but I guess, maybe more modest in terms of its overreach? Or, what do you think is going to occur here as a result of Sutphin v. UPS?
Well, making regulations requires a concentration of society's resources, right? It's a notice and rulemaking period open to the public. You have to have hearings. There needs to be alignment. There needs to be news about it. It gets through multiple committees and whatnot. That takes a lot of time. And quite frankly, the state's got other things to do, right? The executive has other things to do. And no one wants to sit in a notice and rulemaking period about RB 89s. That's me somewhat being cynical here, but it's realistic, right? There's other things that the governor might want to do other than revise the workers' compensation law, right? Let litigation figure this out. That's why I always, and I say this to folks all the time, judicial rulings and, board panel rulings, they make law because they can't help it, because there are holes in the system. The system's so complex. There's so many holes in the system, and these decisions bridge these holes. They bridge the gap there. So what I think in the future is that board subject numbers may not be written more modestly necessarily, but I think the board will, the board itself will not reject something because it might get a slap on the wrist and be found to have abused its power. Maybe the text of the subject numbers don't change, but the application of the subject numbers change. And that being said, again, playing tarot cards here, I think this is going to be the future for compliance forms, EDI forms, right? Section 21A, accepting without liability, right? It's a very complex area where statutes and regulations meld, and the board says, I have this subject number and this is what you have to do in order to X, Y, or Z, right? In order to obtain your goal. Once the board counters the text of its own subject numbers, that too, I believe, will result in an abuse of discretion.
That's incredible. I mean, we're talking about playing tarot cards almost as, I don't want anybody to think that has some, like mild application here. That's very, very far reaching in terms of whatever happens with this, right? This isn't a decision where I think, I think we can guarantee that the board and the courts are looking at and saying like, okay, this is just a one-off, right? Like we're going to just do as we please and it won't ever be back here again. I think this is a big message. So great discussion, Addison. So I think that's a great way to cap it. You know, your future prediction, your tarot card pull, if you will. So for you, Addison O'Donnell, happy birthday again. And to Atticus Finch, Boo Radley, and Scout, you live on forever in our minds and hearts. For all those parents out there, please make your kids watch Schoolhouse Rock, because if the two of us still remember it, that means that it has some lasting impression on our knowledge of how the government operates. We'll be right back with the 2025 Mock Trial Committee, which consists of 2024 champions Karen Olarte, Moshe Allweiss, and Anthony Iler. Stick around. And welcome back to the show. It's the Third Fridays podcast, April 2025. More than a quarter of the year is gone. But we want to preview this season's mock trial program, because April of every year starts those alarm bells for all our litigators and mentors this year. That mock trial season is starting, and who better to introduce than last year's champions? We have Karen Olarte, Moshe Allweiss, and Anthony Iler. Welcome to the show, guys.
Thank you.
Thank you.
So, you guys as champions last year, you were on the show as the podcast episode, right, in the finals. And now you are helping to co-chair this year's program, right? Do you feel good about that? Do you feel like, great, like I don't have to do this anymore? Do you feel, what are your thoughts when, we started talking about shaping up this program a couple months ago?
Definitely feels great to be on the other side of the table. And it feels great to see how far we've all come, especially from last year's program into this new year's program. So I would say from individual and then overall mock trial, we've developed so much.
I was going to say the opposite. I kind of miss partaking in the mock trial part of it. I only did it for 1 year, so I was still getting my feet wet, but it was a great experience, and I was kind of looking forward to it again. But happy that I was able to, come out on top and help people who are in it now.
That's actually very interesting, because I feel like, as the person that is, mostly running this every year, right? I feel like people say that to my face, right? Like, oh, I wish I could play again. I wish I could, really compete. I actually believe you, Moshe, because when you were champion last year, right? You had like 4 or 5 months under your belt?
Yeah, pretty much.
And when you started with that amount of experience, you could, as good as you are, you could not have possibly thought that, okay, like I'm ticketed to win this thing this year, right?
No, I was just expecting to pick up some pieces of information, use it in the personal cases that I have, and kind of deal with it next year.
And so when we introduced the program this year to the firm last month, I'm sure there were people that are in your shoes of what you were last year, right? Saying like, how could I possibly win? Like, what would you say to them, attorneys with less than a year experience, or even paralegals too? Like, what did you say to them? Because we actually use that as a way to say, like, this is something that really anybody can apply, and not only what you said, but use in their cases, but also a good example of actually winning.
Yeah, I tried to speak to people and convince them to sign up for mock trial, no matter how much experience they have. Just, it's good camaraderie. One, you get to talk to people who you probably haven't spoken to or see in the office if they work virtually. So that's just a very nice piece of it. But also just kind of seeing how different people think and using that in your case, and also just using it for the fun of mock trial to kind of get better at litigating, feeling more comfortable speaking in front of people. Most people, dislike that part of it the most.
Which is, I think it's normal to feel a little bit nervous about it. I don't want to I guess, downgrade like the difference between litigating in court or speaking to a client on the phone, right? Or doing a client file review, all the things that we do outside of, work with each other versus speaking in front of your peers, right? But maybe that's a question for you, Anthony. Anthony, you've competed as a litigator. Now, then you won as a mentor last year. What is the difference between competing in mock trial with your peers around you versus, your extensive career litigating court, speaking to clients on the phone, negotiating settlements with adversaries, a whole 9 yards? Like, what is the difference there?
So, me personally, I'm just a hyper competitive person by nature. So it's one of those things that, like, when the lights go on, whether it's court or, mock trial, like, I want to try to win. So for me, I don't feel that much of a difference. And I think a lot of the people in the firm kind of are like that, they want to win. Like, we have a lot of people that are pretty competitive. But even for those who aren't naturally super hyper competitive, I think it's so valuable because it gives the participants a chance to, like, practically understand what a lawyer is doing. So when you look at even a subpoena response or a C3, like, what you're even looking for, and it kind of brings the training that we get to life. So for those people that learn by doing, even if you're not naturally a person who likes to stand up in front of a room or be the center of attention, you get a chance to kind of flex that muscle. You get a chance to do it. And I think actually it's pretty close because in court, you want to win. Before the board, you want to do well for your client. But when you're in mock trial, you want to impress your coworkers, and there's definitely incentives to try to do well. And I think most people treat it like it's something important. So I think it is a pretty close facsimile.
So then putting that together, right, Karen, as you won last year as a paralegal, and in prior iterations, you were close, and you finally, rose to the challenge and won the title last year. Did you get the feeling that, if someone like you is litigating in the competition, what does that mean for someone who, just started at the firm, right? Are they thinking, man, someone like Karen's in there, how can I ever measure up? She's been doing this for a couple years. Because you spoke to a lot of paralegals about applying and were very successful in talking about your experience. What do you think is in their heads about this program and what they're expecting?
I think in everyone's head, it's hesitant because, again, it's their first time, their first year signing up. But I like how Anthony said, like, he's competitive. So I kind of played with that as well. Like, Lois, they teach us, like, competitiveness is in our blood, in our practice. We're taught to be very chaotic and creative and with our arguments and with communicating as well. So I basically just talked to everyone and told them, the information, it's going to come easy. Yeah.
Cool. And I guess, so when we did introduce, the program, Anthony, you were on PTO that day, and Moshe, you saw this impromptu skit that Karen and I did. You can be honest if it was really terrible, because we probably put it together that morning. No, we actually put it together that morning, not probably. And can you grade our acting skills? If you had to grade us right now, what would those CAP scores be?
I mean, creativity would have to be an A. That's definitely. Professionalism could be up there too, but service to the craft is also an A.
Yeah, I think that it felt very, I don't know what the word is, I guess, but just very quick and rushed when we were doing it. But I've definitely heard from people saying, like, hey, is that a real case? Is that, like, where'd you guys get these facts? And there are bits and pieces from multiple cases that we've talked about that we're putting in there. Right. But the fact pattern is kind of juicy. Do you guys remember any pertinent details about our fact pattern that you think our listeners would enjoy?
I think one of the interesting parts that we have that I haven't dealt with in an individual case, but I'm sure people have, is having two claimants that interacted with each other that caused the accident that you're dealing with, and how it kind of impacts each other, information that you can get from the other side. I think that's really interesting and has a lot of facets that are definitely going to need to be explored.
Yeah, so like, I guess in that skit, right, Karen and I were the claimants, right? We're not going to be those actors and actresses for the entire duration of the program. How do you think the litigators will respond to that, Anthony? So Anthony, put yourself in the shoes of a litigator. You see a skit happening where two claimants are involved in the accident and they could potentially be witnesses for each other. How do you think the litigators will respond to that kind of scenario?
Yeah, so it is interesting, and it's funny because the fact patterns, I mean, obviously intentionally so, but it's set up that, I mean, there's enough there that if you're defending this claim, you could say something's kind of going on between these people, or, you know, maybe there's a similarity, and you can try to play off the similarities between what happened to them and, you know, whether there was an actual accident or not, whether, you know, they go to the same doctors and, you know what I mean, and try to build a case or at least skew the evidence in that direction. But there's also enough there where, like, it's clear that there's a thing that happened and people saw it. So I think that just falling back on our training, what we had, just lean on the facts that are, you know, the most favorable to you. It is a little weird that to be in a situation where someone could be a potential witness, you know, in your own case. But I think there's enough there for both sides to definitely, you know, pick the things that help them and, you know, deal with the things that don't and try to make solid arguments.
I think there's also like this testing ground, right, for just stuff that you throw against the wall, right, and see what sticks. I think this is a perfect arena for that. Now, people might not be familiar with, I guess, what a mentor does for mock trial. And, you know, Anthony won that role last year. Now, you guys, Karen and Moshe, as former litigators going through it, I guess compare your experience dealing with, you know, mentors last year and how they helped shape, you know, what you were doing, your arguments you were making, and, you know, the coordination you had within your teams, but then versus what we're doing with mentors this year. What do you think you're expecting from either the mentors or the litigators in response to how the mentors are doing?
I think the difference last year is it was a little bit more of a back and forth where it was kind of the first time that everyone was looking at it almost together. You had some ideas beforehand, but you were really fleshing them out more. Here, you go into it with a little bit of a plan from the mentor. And then at that point, that's when everyone on the team really takes it and runs with it. And you kind of take the specific plan that each, you know, attorney or paralegal has that they want to try to elicit in the defense or prosecution, whatever it may be. And that's kind of where they say, oh, what about this? How about we explore this? And that's where I think you're saying you throw things at the wall and kind of see where you can get with it.
Yeah. Anything from you, Karen? Anything to add to that?
I would agree. Like last year was very brainstormy and like from everyone else and getting the different mentors' perspective on how they would approach litigating each prompt versus this year would be more unified. Everyone is starting at the same baseline and everyone has that opportunity during office hour to discuss and ask those specific questions, and that will benefit each individual at the prompt.
Yeah, I think this year kind of puts everybody in a position to contribute themselves without being pushed to do so.
Yes.
Right? When you have all the mentors giving anonymous action plans and the litigators getting to see, you know, which plan they like and then signing up, you know, for the office half hour, I'm very interested to see how someone views a written plan, right? Imagine like, you know, you get a new file from your client and they give you a directive of how to litigate, right? And sometimes it's very specific and detailed. Other times, right, you'll get that email and say like, hey guys, do your best, right? Like do what you do, right? I'm open to anything. So I'm very interested to see how these action plans, one, are written and then also perceived by the litigators to then pick the person who they think fits how they want to, really litigate and go about it. Because I think that is going to be probably the most, it's the most new wrinkle we have this year, right? It's this this anonymous action plan so that, you're not just picking like, oh, I like this person. This person's my friend. Or, oh, we're all remote. Well, let's all be a remote team together, right? Like, I think it's going to really be based on the content and the tone and the direction of the plan, which puts the mentor in a position almost to kind of be like a client, right? Like the mentor is going to be that perfect client that, says, okay, here's your foundation, but also here's a little wiggle room to kind of shape, your own ideas, your own plan. What do you guys, when you guys see that, right, from clients, like, what do you prefer? Do you like the detailed action plans from the client, or do you like kind of as the minimalist stuff?
In terms of directives from the client, I'm okay with a little bit to just say which way they want us to go, but to kind of let us run with it, because it lets us do what we do and really use our practice and like all our training and really put it into play. But I also I don't like when they give us nothing, because then we're, trying to get, okay, well, we need this more information and we need this and we need this. And you kind of it's a lot harder to get all the information and really do what you want versus if they're in it with you, they're more of a coworker than, a client.
Oh, interesting. Nice. Okay, cool. Any final thoughts from you guys? Any last well wishes to our coworkers, our mentors and litigators that will be on stage next week, third Friday, April 2025. Any last words?
I'll say have fun, right? This is a great area to explore your creativeness and being your individual self, and throw your own thoughts into it. Don't be afraid. Don't hold back. Doesn't matter if you're, again, someone who's been here for a long time. If you're within your first year, you still have that chance to win. Moshe is sitting right in front of me. Yep. He won.
What about you, Anthony? Maybe to the mentors, right? What words of wisdom can you give them?
So I think it's important as a mentor, and it's something I tried to do when I was in that role, is you want to impart, what you know and your knowledge upon the people you're working with. You also have to give them an opportunity to find their own voice and to encourage them, the people that you're working with, to do things their way, because stylistically people are different. So just try to make sure that, when someone comes to you and you're discussing with them, that you let them find their voice. And if they're conveying something or the basic idea or the subject matter knowledge that you impart on them, just let them have fun. And to everybody involved, have fun. It's a fun process. Like, you're going to laugh about it. You're going to be on Teams and chatting. Like, did you see that? That was incredible. That was ridiculous. Like, it's just a fun thing all the way around. And don't lose sight of that, especially if you're dealing with people that you don't deal with on a daily basis. Maybe they're on another team. Just, embrace that. You get to know people. You make friends. It's just a really cool process. And, I'd be remiss if I didn't say, Christian, thank you to you. I know you put in a lot of work into this every single year. This year's no different. So, just wanted to at least acknowledge that. Thank you for all the work that you put in. I'm happy to help out this year.
Okay, Anthony, tell me where to Venmo or Zelle you.
There you go. There's the plug.
No, I appreciate it. I think that it's important just to build the collaborative aspect or environment that we have here. So those are great words to end on. So I think that we can end there, right? Thanks to you guys, one, for setting the tone, for winning last year and providing a good example. And to everybody participating on Third Friday, good luck. It's the best choice you'll make of all time. So for Karen Olarte, Moshe Allweiss, Anthony Iler, my name is Christian Cisan, reminding you to defend from day one.